Right, so ladies and gentlemen, dear colleagues and friends, one more time I'm extremely pleased to welcome you to the Center for Social Sciences and Humanities, the CSH, for another fascinating evening of discussion on the many facets of social sciences in India and South Asia. This evening we are extremely pleased to welcome two legal anthropologists, Dr. Kriti Kapila from King's College London and Dr. Anuj Bhuwania from South Asian University in Delhi. They are going to address two different yet very complementary aspects of the access to justice debate. How indeed do you facilitate access to justice for the most vulnerable? Is it in restoring so-called indigenous system, maybe, or is it on the contrary, as the modernists would say, in pushing forward new ideas like public interest litigation, a very Indian sort of public interest litigation, which is, as you know, judge-led and judge-induced, just to paraphrase the famous words of Upendra Baxi. This is precisely what we are going to see tonight and discuss together based on concrete example of access to justice and denial of justice, maybe, in India.
I meet Deoldi Devi in the compound of the court complex in Palampur. The wiry and frail woman in her late 60s who makes a living from selling fried fish next to a hooch stall is unusually excited. Her lawyer has assured her that the judge will pronounce a decision in her case today, and she may be summoned inside any time, she shouts eagerly. We make our way inside hurriedly to the Sub-Divisional Judicial Magistrates Court in Palampur, which is an entry-level court of the Indian judicial system. Deoldi Devi Banam Harnam Singh is the fourth case out of the 12 slated for the pre-live session. That the judge is ensconced behind his desk on a dais slightly above the level of the rest of the room. Leaning forward, he asks Deoldi, "So, Amma, are you sure you don't have anything further to add?" She mumbles that she's now just waiting for a faisla or a decision. He then asks the same of the defendant, her son. Judge Avasthi does not really wait for a response, and instead, adopting a paternal tone towards a man who is perhaps a few years older than himself, begins to admonish him. "You shouldn't have let things come to this, and should have looked after your elderly mother better. It would have saved you a lot of time and money." Then, turning to the audience, he continues, "Kyun ji, galat baat hai na? It is wrong, isn't it? An elderly widow has to resort to court kacheri to get what is due from her son. We're becoming a very selfish society." He announces his judgment. Harnam Singh is to pay a monthly allowance of approximately a tenth of his average monthly earnings to his mother, in addition to food, clothing, shelter, and care in general. And he does so under Section 125 of the Criminal Procedure Code. Rajavasti applies a statute governing maintenance claims in annulled marriages as a legal means to ensure that an elderly parent will be cared for. Deoldi is thrilled, Harnam is disappointed and angry, but both are ushered out of the court without further ado. The joy on Deoldi's face made me think once again about why ordinary people from rural North India bring their domestic disputes to a low court, despite the legal system's reputation for being expensive, long drawn out, and sometimes downright unjust. Scholars of Euro-American law have often asked that if the law has failed to meet its public aspirations, that of justice, how does it retain support among the people? This is mainly for reasons to do with the nature of the public aspirations of the law in India, that cannot be generally regarded as a failure. Secondly, it has to do with the distinctive relationship between law and culture in India. Moreover, explicit comparative evaluations made between state and alternative dispute resolution institutions made by rural people in India force one to rethink about the impetus of legal consciousness in different terms. I attend to two different kinds of context specificities that form the basis for legal consciousness in India. The first is the relationship of state judiciary to other forms of dispute resolution, and the second is the contest between legal and cultural norms. At the time of my doctoral research, there was no such permanent Lok Adalat or family court in Himachal Pradesh. Nonetheless, non-permanent Lok Adalats and family courts were convened from time to time on a need basis within the province. These types of non-permanent Lok Adalats are convened at the discretion of the judge and usually handle petty or long-running litigation. They typically last a day, and their membership is reconstituted afresh every time. During the course of my fieldwork, only one Lok Adalat was held in the Palampur Subdivisional Court, and the judge, along with the panel of lawyers, decided on which cases were to be assigned to the Lok Adalat. These cases were, as it turned out on the day, mostly from those registered under Section 125, that of maintenance. The promise of equality for all in an underdetermined notion of the future therefore presents itself as powerful and for most part an incontrovertible proposition, whose attraction few can deny in a milieu ill-determined by hierarchy. In fact, it is often the functioning or implementation of the law, rather than its content and its force, that usually comes for criticism. Injustice, too, is not seen to issue from the nature of the law itself, but from the indolence or slovenliness of its executors.
From the 70s onwards, you see the emergence of informalism in a very big way, not tied to the global global agenda yet. It becomes tied later, after 91, to the ADR, the Alternate Dispute Resolution world. But in the mid-70s, with Mrs. Gandhi's assault on the judiciary, and in the language of the committed judiciary and the fact that the Indian judiciary was identified as an elitist institution, as a pro-landlord, as insufficiently decolonized, and Mohan Kumar Mangalam and Mrs. Gandhi launched this incredible assault on the judiciary's, and the principal ground was pretty much that it was not autochthonous enough, that it was not Indian enough, and as part of her, this I've written about elsewhere, the story in much greater detail, but to me, what happens with this, I mean, in the 42nd Amendment during the emergency, she inserts this provision called Article 39A in Directive Principles on Legal Aid. But the interesting thing is that while we're talking about legal aid, what is happening instead is, instead of legal aid is strictly speaking what? Is just providing cheap legal services to the people to the indigent. But not by changing the institutions itself. But what we have in India instead is that the institutions themselves are changed. It's not that, I mean, what I'm trying to say is that new parallel institutions like Lok Adalats are set up at the lowest level, tribunals at the middle level, and PIL emerges at the highest level. Going to official statistics, in 1998, Delhi's slum population was approximately 3 million, about 600,000 households. Then when the next survey happened in 2011, the official figure of the slum population of Delhi had fallen from 3 million to 2.1 million, about 420,000 households. So this fall is remarkable because it's the only other period in which there was such a massive recorded fall in slum population of Delhi was between 73 and 77, when it fell from about 500,000 to about 100,000. And this fall in 73 and 77 is infamous because this was the period when the emergency was in force. And one of the most notorious achievements of the emergency was a massive program of forced relocation of slums. So how did this more recent decline in the slum population take place? What we see in this case is that while the emergency regime saw a breakdown of political negotiations as the technocratic elite ran amok, the period between 1998 and 2011 saw a very similar process unfold. Only this time, the vehicle was Delhi's appellate judiciary.
Thanks both of you for wonderful presentations, and I think it's quite interesting the ethnographic evidence that Anuj has provided. So many court cases and examples. It was really fascinating. So just kind of to balance it, I'd like to ask Dr. Kapila a little bit more about your ethnographic setting of the tribal group that you interviewed, that you did your research with. And the reason I'm asking this is also because of the second question. I just wanted to know, what about the pockets of resistance towards this sort of judicial structure? I mean, the women who obviously want to go to the courts because they feel that they are better heard out there. Did you also hear some sort of resistance about that as well, perhaps in terms of the time that they take, or I don't know, certain other issues, just something. So the reason I'm saying that is because I was wondering if there was any voice of another sort of system, which is not the panchayat, but better than the panchayat, better than the sort of legal system, just their voice, in your ethnographic work.
This is not that this this is expensive. Apart from that kind of expeditious reasoning, he said, "What are you going to get? Her affections have already moved elsewhere, and what are you going to get? She's not going to be loyal to you. She's gone now." And so ultimately that was the outcome. That and this outcome would not have rested on a very different set of jurisprudence, rested on a very different kind of reasoning, and was not, as I said, culture necessarily is not restricting, inhibiting necessarily. So that's what I would say. So people did choose expeditiously between separate positions, is what I want to say, where they always want to max out their chances, and whatever helps. And why not? Yeah.